Good evening, ladies and gentlemen. I'm Jenny Morgan. I'm the interim dean of the law school while the university engages in an international search for a replacement for our former dean, Carolyn Evans. On behalf of the Melbourne Law School, it is a great pleasure to welcome you to the 2017 Sir George Turner Memorial Lecture. I'd particularly like to acknowledge here the presence of our guest speaker, Judge James Crawford, and my colleague, Professor Sandhya Pahuja, who will host the Q&A at the end of the lecture and give a vote of thanks. We meet today on the traditional lands of the Wurundjeri people of the Kulin Nations, where the university is built, and I would like to acknowledge their elders past and present. The lecture is being recorded and photographed, and it'll be available on the website. If you're not comfortable with photographs being taken, can you please let the event photographer know? Can I also remind you, and I hope I reminded myself, to put your phones on silent. I'll have to check mine as soon as I sit down. Tonight's event forms part of the Sir George Turner Memorial Lecture Series. It's an annual lecture series established when Grace Melvin Turner bequeathed in her will in 1944 the establishment of a law lectureship in memory of her father, Sir George Turner. I then went and thought, well, who is Sir George Turner? Pardon my ignorance, but fortunately the wonderful Australian National Dictionary of Biography could help me out, because he was Mayor of St Kilda, an area I live in. He was also Premier of Victoria. He then left Victorian politics and became Federal Treasurer and introduced 4 different budgets. He later resumed legal practice in partnership with one of his sons, George John, and their firm merged with the firm of Core and Core in 1907. And he was also, in 1906, he was chairman of the Commissioners of the State Savings Bank of Victoria. So now you've had your Sir George Turner lecture history. I want to turn to introduce our speaker tonight. James studied law at Adelaide and Oxford universities. He's a judge of the International Court of Justice, as I'm sure is well known to you. He was, from 1992 to 2015, Whewell Professor of International Law at the University of Cambridge. He also held chairs at Adelaide, Sydney and La Trobe universities. And he's one of the few people who said to me, how long is your sentence as Dean? And that's because he too has served as a Dean, both at Sydney Law School and at Cambridge. He was responsible for the International Law Commission's work on the International Criminal Court and for the second reading of the ILC articles on state responsibility. During his practicing career, he was involved as counsel, expert or arbitrator in some 100 cases before the International Court and other international tribunals. We're very grateful to Judge Crawford for kindly agreeing to deliver this evening's Sir George Turner Memorial Lecture and to share his extraordinary wealth of knowledge on international law. So I'm sure you will really enjoy his unique insights this evening. So welcome, Judge Crawford.
Thank you, Professor Morgan. I should preface my remarks by saying that as a judge of the court, I can't obviously express any opinion on current issues. And if I appear to be expressing opinions in the course of this lecture, that is an optical illusion. I didn't do so. I will deny having done so. And please don't attribute any views to me which you may infer that I might hold. As a public health warning, my health rather than yours, it must be said. The international legal system has been showing signs of instability. States have been withdrawing from multilateral treaties. For example, South Africa from the Rome Statute from the International Criminal Court, the United Kingdom from the European Union, the United States from the Paris Agreement. Some states have been withdrawing from their investment protection treaties. Other signs of insecurity include non-appearance before international tribunals, rejection of unfavourable decisions, a weakening of the international court's optional clause mechanism, denial of responsibility for refugee flows, and so on. What does all this portend? Are states entirely free to choose from the smorgasbord of international legal rules on offer? Are they free not to dine at all, to reject the underlying institutions and with them their commitments to each other? That's the question which I think a lot of people are asking in the present climate. I can't answer that question in the course of 45 minutes, but I can reflect on it to some extent and hopefully help you to answer it, as I think everyone needs to do in the present environment. The international system is a sort of layer cake. At least it's a sedimentary formation. It has a core of institutions and associated rules which might be described as comprising the necessary law of nations, to use Vattel's term from the mid-18th century. No doubt international law is not necessary in the sense of historically inevitable, still less logically required. But it's implicit in the way we have organised the world over time. Its necessary core includes the modalities of interstate relations, the principle of the formal equality of states, the general capacity of governments to represent the state, the processes of treaty making and negotiation, and so on. It's interesting to see a reflection of this common core in the joint declaration on the promotion of international law issued by the Russian Federation and China on 25th of June 2016. They said, and I quote, "The principles of international law are the cornerstones for just and equitable international relations, featuring win-win cooperation, creating a community of shared future for mankind, and establishing common space of equal and indivisible security and economic cooperation." This, I hasten to say, was Russia and China. States enjoy their rights on the basis of independence and on an equal footing, and assume their obligations and responsibilities on the basis of mutual respect. And they went on to identify two core principles of international law. First, the principle of non-intervention in the internal or external affairs of states, and in particular, any interference, this is another quotation, by states in the internal affairs of other states with the aim of forging change of legitimate governments. And they also referred to, and I quote, the principle of peaceful settlement of disputes, though they qualified their endorsement of this principle by saying that all dispute settlement means are based on consent and used in good faith. A cynic might observe that perhaps the most important are precisely the interference of one of them in the United States presidential election, and the rejection by the other of a decision of a tribunal constituted under the Law of the Sea Convention concerning maritime jurisdiction over the South China Sea. Evidently, such declarations cannot always be taken at face value, but it is, I suppose, something that they are made. So against that background, the question is, are states free to withdraw from the international system? And the first point to be made is that there's only ever been one attempt explicitly to withdraw from the system of international law. It was made by the Soviet Union, the RSFSR as it then was, following the Bolshevik Revolution of October 1917. It was a doctrinal attempt. It involved the Russian authors and the theory derived from Marx that international law was a bourgeois superstructure which was not needed by states in a socialist commonwealth. In fact, it was never followed by the Soviet Union. The Soviet Union entered into treaties from the beginning. Its initial stipulation of repudiation of Tsarist debts was qualified. It relied on the legal personality and legal rights of the Russian Empire. And eventually, at the end of the decade, the thesis of the obsolescence of law for socialist states was repudiated by the authors who had adopted it. China didn't attempt the same thing in 1949. Of course, China had come late to the international system and was in effect coerced into it in the mid-19th century by military action. Notwithstanding that unpromising background, from the beginning of the modern period in China, it accepted its place in international law and relied on the rights of its predecessor governments. So the position is that states attempting to withdraw are rare indeed, and that the only recorded attempt at a comprehensive withdrawal was an immediate failure. We might ask why that is so, because international law obviously doesn't have a lot going for it, confronted with very powerful states. The answer is fairly simply that you have to use language when you deal with other entities at the international level. International law provides a part of that language, not all of it, but a significant part of it. If you want something from a partner, whether it's one or many, you have to give something in return. So reciprocity and compliance are built into the structure of the system, even if they're sometimes lacking. There's a tendency to normalization even after revolutions. And we see that in a variety of contexts. I turn from the system itself to its consensual manifestations. So far I've been talking about the necessary law of nations, but so far the concerns that I began this lecture with have been felt more in respect of Vattel's other category, the voluntary law of nations, international law which states choose to have, dominantly through multilateral and bilateral treaties. The post-1945 framework, in detail if not in principle, is the work of negotiation of treaties. Many of these contain express provisions for withdrawal, and some which do not are subject to an understanding that there can be withdrawal on notice. With respect to such treaties, it's a question of policy rather than law, whether or not to withdraw, whatever the implications from an international public policy point of view may be. But international law governs the withdrawal process. The point I've made about socialization into the system applies equally in respect of withdrawal of treaties, as the examples I'm about to give will show. It may affect the modalities and consequences of withdrawal, especially when it comes to the vested rights of parties or to pending proceedings. National constitutional law may also be relevant. So it's helpful to review the withdrawal cases, whether or not they encapsulate legal disputes, since the focus of current political discourse on international law very much focuses on such cases. They form a broad spectrum. One end of the spectrum is the abandonment of treaties not yet concluded. One of the first acts of the present United States administration was to abandon several of the multilateral trade treaties that were being arduously negotiated. The Transatlantic Trade and Investment Partnership, TTIP, although the United States' position on it is not free from ambiguity, has in effect been shelved. Then there are examples of unsigning treaties requiring ratification but not yet ratified. For example, the United States unsigned the Trans-Pacific Partnership Agreement by notification to the depository New Zealand on the 4th of February 2016. Both the United States and more recently the Russian Federation unsigned the Rome Statute for the International Criminal Court. Neither became a party to it. Such notifications are not unlawful, as signing the Rome Statute does not constitute a means of expressing consent to be bound to it within the meaning of Article 11 of the Vienna Convention on the Law of Treaties. Then slightly further along the spectrum are cases of withdrawal of provisional application of treaties, an issue in the UCOS case involving the Russian Federation. The field of investment arbitration which UCOS concerned is also a much discussed arena for withdrawal from treaties which have been definitively concluded. And again, it's standard for investment treaties to provide for withdrawal. But it's also standard for them to provide for long periods of time when they continue to have effect post-withdrawal. So the withdrawals that have occurred have tended to have a diminished effect in the short term and even in the medium term. Let me take in more detail 3 examples of withdrawal which have been very much in the news in the recent past. I'm going to take the South African withdrawal from the ICC, Brexit, and the US withdrawal from the Paris Agreement, and say something about each of those. There's no inherent right on the part of states to withdraw from multilateral treaties. The position is regulated by Article 56 of the Vienna Convention. There has to either be an express withdrawal provision or an understanding that withdrawal is permitted. There's no inherent right to withdraw. And there's a process for withdrawal, including the giving of notice, presumed to be 12 months' notice if no other provision is stipulated. In fact, in the 3 cases I've mentioned, there is express provision for withdrawal, and it's been relied on in various ways. Let me start with this withdrawal of South Africa from the Rome Statute. As is well known, the African Union has been campaigning against the International Criminal Court on grounds of singling out African statesmen, former heads of state and so on, for prosecution. The African Union Assembly in January 2017 adopted a withdrawal strategy. The 3 withdrawals were the Gambia, Burundi, and South Africa. The Gambia withdrew its withdrawal after a change of government in the election. Burundi has not withdrawn its withdrawal, but South Africa has done so. And the circumstances in which it did so are of exceptional interest. The executive's decision to withdraw South Africa from the Rome Statute without parliamentary approval was challenged before the High Court as being unconstitutional on both procedural and substantive grounds. In Democratic Alliance against Minister of International Relations, the court noted that the provision of the Constitution dealing with the conclusion of treaties required parliamentary involvement, and there had been parliamentary involvement in South Africa's ratification of the Rome Statute. South Africa was originally part of the like-minded group. The Constitution was silent, and international law is silent, on the question whether, if Parliament has been involved in the conclusion of a treaty, it must also be involved in withdrawal from the treaty. The court was faced with an open question, but it said on the separation of powers grounds, applying Section 231 of the South African Constitution, that where a treaty had been approved by Parliament, the executive lacked the power unilaterally to withdraw from the treaty, except after parliamentary approval. So separation of powers applied to withdrawal of treaties. 3 points of general interest may be noted. First, the court highlighted the importance that any parliamentary process be properly carried out. It criticised the use of emergency procedures, stating that unexplained haste would constitute procedural irregularity for the purposes of the Constitution. It's a very strong finding, and it may have played a role in what has subsequently happened. In particular, the National Executive is not entitled to dictate timeframes to the legislature within which to consider any bill before it. Public participation doctrine required substantial involvement by the legislature. The second point is that the South African court made no reference to the Miller decision of the United Kingdom Supreme Court, which had been cited to it the decision had been made a month earlier, and I'll come on to it. This was obviously an autonomous South African constitutional decision in relation to involvement in a major international treaty. The third point is that the court was prepared to go further than international law does in imposing the separation of powers in relation to withdrawal from treaties. In the event, South Africa revoked its withdrawal by note verbal of 7 March 2017, wittily entitled Withdrawal of Notification of Withdrawal. There was at a time, and it may still happen, that South Africa would go to the South African government would go to Parliament and get approval to withdraw, in which case the next document in the list would presumably have been notification of withdrawal of notification of withdrawal. But that hasn't happened. The government accepted the High Court's decision, and earlier indications that it might seek parliamentary approval to withdraw have not been followed through, despite the executive's current distaste for the Rome Statute. South Africa remains a party. I turn to the United Kingdom's withdrawal from the European Union. And again, a constitutional issue was raised to the extent one has constitutional issues in the United Kingdom. In the case Miller against Secretary of State for exiting the European Union. The United Kingdom now has Secretaries of State for exiting things, whereas normally Secretaries of State are there for areas of activity. The area of activity of exiting the European Union seems to be an autonomous one. Article 50 of the Treaty on European Union provides that member states may withdraw in accordance with their own constitutional requirements. In Miller, the Supreme Court, by majority, upheld the decision of the Divisional Court that legislation had to be passed before the government could give its notice of withdrawal under Article 50. That was not an inevitable decision. You could argue that the withdrawal process under Article 50 occurred exclusively at the international level, and that the impact on rights and obligations of individuals would only occur at the time of actual withdrawal, where legislative sanction would obviously be required, and that wasn't in dispute. But the Supreme Court went further and said, where Parliament has been involved in a process which integrates an international treaty into the domestic system in the way in which European law was integrated in the UK legal system, the impact on individuals of withdrawal is such that it requires parliamentary sanction at the preliminary stage. A far-reaching decision, and one, as I say, which was not inevitable. In fact, Parliament then approved, in a rather rapid process, in a rather short form, the decision to withdraw, which had obviously been earlier sanctioned by a referendum. Looked at from an international law point of view, the case gives rise to certain reflections. First of all, there is the basis and status of the current negotiations on the terms of withdrawal, negotiations which have proved much more difficult than anyone expected. According to Professor Armstrong, and I quote, "It is perhaps the irony of Brexit that the EU is not a state with complete sovereignty and freedom to do what it wants, how it wants. It remains an international organisation, and the powers of its institutions are defined in and limited by its founding treaties. This legal context shapes the form of the legal relations with non-EU states, including the approach to trade deals." So the fact of the EU as an international organisation is limiting the scope of the EU for negotiation and limiting the options for the United Kingdom in turn. There is considerable tension within the EU legal order between the underlying international law framework of treaties and the internal law of the EU, which is not international law in any straightforward sense. When negotiating within the EU for a situation outside it, which is what's going on at present, the hybrid character of the EU is very much an issue. The United Kingdom remains an EU member until the notice period expires or is unanimously extended, which is unlikely. So the effect is that the jurisdiction of the European Court, which is proving a major issue in the negotiations, remains by operation of law in the interim period. This brings me to a third point, which concerns dispute settlement. There is dispute settlement over the terms of Brexit itself, and in accordance with the European legal structure, it's actually impossible for the United Kingdom to avoid the possibility of Court of Justice involvement in determining the legality of the eventual agreement to withdraw. That can be done by other states referring the matter to the court. It can be done by the Parliament referring the matter to the court. And it's not something from which the United Kingdom can simply abstain or absent itself. Again, to quote Professor Armstrong, while Article 50 is not constitutive of a right to withdraw, it does nonetheless lay down binding EU legal norms and procedures for the exercise of that right by a member state. That Brexit will be concluded through Article 50 is to accept the continuing political and legal authority of the EU, including the Court of Justice, until withdrawal has occurred. And then there's the problem of continuing jurisdiction of the European Court in any transitional period after British withdrawal, something which the United Kingdom originally excluded entirely, but which seems to have come back, at least in embryo, in comments recently made by Prime Minister May in her Florence speech last week. She said, and I quote, "Where there is uncertainty around underlying EU law in the transitional period, I want the UK courts to be able to take into account the judgments of the European Court of Justice with a view to ensuring consistent interpretation." She also added, "To make this partnership work," this is the partnership that will be created by the withdrawal agreement, "because disagreements inevitably arise, we will need a strong and appropriate dispute resolution mechanism. This could not mean the European Court of Justice, or indeed UK courts, being the arbiter of disputes about the implementation of the agreement between the UK and the EU. It wouldn't be right for one party's court to have jurisdiction over the other, but I'm confident we can find an appropriate mechanism for resolving disputes." End of quotation. So you see the dynamic. A state in rejecting dispute settlement nonetheless has to accept dispute settlement over the terms of the rejection. And that's the dynamic which is currently occurring. And the Prime Minister went on to refer to the possibility of dispute resolution in the context of possibly arbitration in the post-transitional phase period, whenever that will be. Now, it's obviously inappropriate for me as an international judge to comment on the legalities of that process. But I do make the reflection that engaging in the process of withdrawal carries with it legal consequences, which seem to be inevitable. You're not skating on an empty or a clean slate. You're working within the framework of what exists. In that context, it's been suggested that the EFTA court might be an alternative which could be adopted. And that's been endorsed indeed by the president of the EFTA court itself. EFTA is the mechanism for states which are closely associated with the European Union but not actually party to it, for example, Norway. But the present thinking of the United Kingdom government seems to be that some form of international arbitration is required. And what we see here is an acceptance, one might almost say in extremis, that criticised mechanisms for dispute settlement need to be replaced by other mechanisms not yet criticised for dispute settlement. We see the same phenomenon in the context of the European Union's proposal for an international investment court. If you listen to the criticisms of international investment arbitration, you would think that the simplest thing to do is to abandon it. But those criticisms which have been salient in Europe are leading the European Union to adopt a stronger form of dispute settlement. We can argue about the details, but the dynamic is still there. My third example of withdrawal is provided by the United States announcement that it will withdraw from the Paris Agreement. And I argue that the same dynamic, what I might call a dynamic of reluctant involvement, can be seen equally in this case. Initially, the United States was not clear whether it intended to comply with the withdrawal procedure set out in Article 28 of the Paris Agreement, or whether it intended instead to withdraw with immediate effect. President Trump was characteristically imprecise on such subjects. International law does not confer, as I've said, an unqualified and unconditional right to withdraw from treaties. And Article 28 of the Paris Agreement provides that you can only withdraw on 1 year's notice 3 years after the treaty is entered into force for you as a state. That has the somewhat ironic consequence that if Article 28 is relied on, the United States withdrawal will take effect several days after the next presidential election. The United States could possibly have avoided that by withdrawal from the underlying Framework Convention on Climate Control, which has a 1-year withdrawal clause. The Framework Convention, unlike the Paris Agreement, was a Senate treaty, was endorsed by the Senate, and there is legal uncertainty in the United States over the Miller question. That is the question whether, in the case of a Senate treaty, withdrawal requires Senate action. The only decision involved a bilateral Supreme Court decision involved a bilateral treaty concerning Taiwan and was decided on special grounds. In fact, the United States seems to be relying on Article 28 as the mechanism for withdrawal from the Paris Agreement. A communication of 4 August 2017 by the United States to the Secretary General said, and I quote, "The United States intends to exercise its right to withdraw from the agreement unless the United States identifies suitable terms for re-engagement. It will submit to the Secretary General, in accordance with Article 28, formal written notification as soon as it is eligible to do so." So the language of repudiation is expressed in the terms of acceptance of Article 28. The United States has not yet withdrawn from the Paris Agreement, but has expressed its intention to exercise its right to do so in due course, leaving the door open to negotiation. And there's no reference to the Framework Convention, which the United States intends to remain a party to. The United States provided a number of reasons for its withdrawal. It's not appropriate for me to engage in general debate on the propriety or public policy associated with that decision. But I do have to say something about what was put forward by the President as the main reason for withdrawal. The crowning argument was that the Paris Agreement impinges on America's sovereignty. And the President said, I quote, "There are serious legal and constitutional issues. Foreign leaders in Europe, Asia, and across the world should not have more to say with respect to the US economy than our own citizens and our elected representatives. Thus, our withdrawal from the agreement represents a reassertion of American sovereignty." The United States will cease all implementation of the non-binding Paris Accord and the draconian financial and economic burdens the agreement imposes on our country. End of quotation. That's a rather remarkable statement. In particular, the non-binding Paris Agreement imposes burdens on the United States. Of course, the Paris Agreement was very carefully negotiated with an important distinction between the procedural mechanisms for the adoption of targets for emissions and the content of those targets. And that was done particularly with regard to United States concerns. The basic point is that the United States exercises its sovereignty in negotiating, signing and ratifying the Paris Agreement, and by making voluntary commitments to the Green Climate Fund. It's not too much to say that the Paris Agreement was structured around United States concerns as to the previous Kyoto Protocol. The second point is that the US chose for itself what level of ambition to commit to in the NDCs, and that itself was an exercise of US sovereignty. Sovereignty is not something which is unaffected by previous exercises of sovereignty. Previous exercises of sovereignty do not amount to abandonment or abrogation of sovereignty, but they have to be taken into account in what follows. I return to the idea of international law as a sedimentary formation. What should now be clear is that states can withdraw from some of its layers of sediment more easily than others. Of course, sediment in time turns to rock if there is enough of it and if it's not eroded. So too with international law. As its base is a solid set of principles, norms and institutions, the fundamentals of the post-war legal structure. It will be difficult for any state to effect a wholesale withdrawal from this solid base. It has survived the worst of the Cold War and many other international crises. There's a concern at present that what we're seeing is a wholesale erosion of that international system, a breakdown. Well, we've experienced breakdown in the international system before. And I have to say, I think in my view, this is not it, whatever concerns we may have. If you want to look at breakdown, look at the late 30s, when reasonable states with grave policy concerns in effect repudiated the League of Nations covenant because they had no faith in its processes. The United States, in engaging with the rest of the world, engages through the existing mechanisms, including the Security Council, because that's what's there. Some states, it's true, have been sceptical of the promises of multilateral treaties. The United States has failed to ratify numbers of the treaties it has signed and significantly influenced. notably the Law of the Sea Convention of 1982, which it nonetheless frequently invokes, for example, in relation to the South China Sea. But its lack of participation in particular multilateral treaties has not prevented the development of a substantial body of new international law over the past 70 years. The Law of the Sea is a good example. International law is flexible enough to accommodate dissenters. As some states retreat, we can expect others to step forward, as witness strong statements from the European Union and China of their commitment to the Paris Agreement. Moreover, like any legal system, international law will only survive if it has the capacity to change and develop over time. There's no inherent rule that everything will proceed in the same line in a linear fashion. There can be advances and retreats, even if the overall picture is one of increasing integration. Adjustments may be necessary to respond to perceived inequalities or uncertainties or to genuine concerns, for example, in the field of population flows. We should also recognise that allowing the possibility of withdrawal by including express clauses in treaties may be the price of getting states to consent to be bound in the first place. Withdrawal is not always to be condemned, but we should also be wary of the increasing rhetoric of scepticism towards international law as a whole. Over time, this may precipitate a larger scale retreat into nativism and unilateralism. We should be ready to defend the communitarian values of international law against this possibility. Thank you very much.
Thanks, James. I now want to introduce my colleague, Professor Sandhya Bahuja. Sandhya is the Director of the Institute for International Law and the Humanities and the author of numerous books, but one of which is Decolonising International Law. So welcome to Sandhya to run the Q&A briefly and give a vote of thanks.
Thank you very much, James. I think before I open the floor to questions, and not in replacement of my vote of thanks, I'd just like to say that, in a sense, that incredibly lucid account for me represents a certain kind of encapsulation of some of, sorry, I should call you Judge Crawford, not James, some of Judge Crawford's concerns over the years, from his book in 1979, The Creation of States, to Chance, Order and Change much later, with the question of the kind of tenacious resilience of an international system combined with the question of how does change enter the world. So I think that there's a very interesting story to be told, as we have heard, in a very rich, doctrinally and with no opinions expressed way, about how we can interpret a certain moment either as a systemic breakdown or in fact as a moment of real opportunity for people interested in international law to think about how change enters the world. So with those remarks, I'm going to invite, we've got about 8 minutes for questions. We only have one microphone, so please put up your hand if you have a question, and I'll take one at a time, or would you prefer me to gather them? Okay, so let's see. Do we have a question from the floor? There's one over here.
James, Judge Crawford, I was wondering if you could comment on the dynamic of reluctant engagement you spoke of in the context of non-appearance in international arbitration.
Non-appearance was a problem in the 70s, where there were some significant examples. France didn't appear in the nuclear test case. The United States didn't appear in the second phase of Nicaragua, and there were some other examples. It then largely disappeared as a problem. Non-appearance disappeared. And the tendency was for states to turn up and argue cases before the court. There was a significant example of reluctant engagement in the resumed nuclear test case brought by New Zealand against France in the mid-90s. The French came along, but they didn't wear their robes because they thought the court didn't have jurisdiction. Judge Schwabel, in an apt comment, referred to that. It does great credit to Sir Arthur Watts, who was the first Anglophone common lawyer to be retained by France in an international dispute, an international case before a court, that he did wear his robes. That was his condition for appearing, but the French lawyers, who normally appear in glorious red, were wearing lounge suits. But they were there, and in fact they won the argument. The tendency of non-appearance has recurred more recently in a number of cases and is a matter of concern. China obviously did not appear in the South China Sea case. The law on non-appearance is perfectly clear. The state it doesn't improve its position by not appearing. The court has an obligation to determine whether it has jurisdiction, which it will exercise in any event, and which obligation it will fulfill in any event, and deal with the issue of jurisdiction proprio motu if necessary. But it is one of the manifestations of the present situation, which is troubling, even if so far the occasions of non-appearance have been relatively few.
Thank you very much. I was just returning to your beginning where you spoke about the China-Russia Declaration on International Law, and I was thinking about your topic, which is withdrawing from international law. And I wonder whether you can distinguish withdrawing from international law from maybe ignoring international law, and whether or not you see a difference between the two. So, for example, in the Russia-China Declaration, they espouse strongly some principles of international law, but leave others off the table. And I wonder whether or not you see a difference between the two and what that impact would have on the international system.
Well, there have always been states have always had preferences for some rules over others. The irony of the declaration was that the two rules they cite are rules which they fairly obviously have had problems with in the recent past. So this is not a case of ignoring the rule which you may be violating. The dynamic of international law is that it engages states even when they violate it. That may sound paradoxical, but international law doesn't have big battalions. It operates over a long time scale. It depends on the judgment of the wisdom of the rules in question over time and the attitude of other states parties to the relevant agreements. And we see, I quote in the book to which Professor Pahuja referred, Chance Order Change, we see the durability of some rules of international law confronted with repudiation. For example, in what happened in East Timor, which I document. So it does move. It sometimes takes time and it doesn't always work. But there's not an alternative instituted rule of law system. There's not a constitutional system that exists as an alternative. It's what we've got. It's what we've got as a result of a series of decisions made over a long period of time. And we repudiate it at our risk.
Your draft articles, which I've been trying to promote here on Facebook, now Articles 16 and 17 speak about, well, I feel that they might refer to the way Australia has pushed, asylum seekers onto Manus and Nauru and saying that this is the responsibility of Papua New Guinea. But from those draft articles, I feel that that's not so. Can I ask that question or not?
Well, I'm not going to comment at all on the current Australian refugee policy or the detention of persons on Manus and Nauru as a matter that could conceivably come before the court, and I express no opinion about it. Article 16 is the general provision dealing with complicity. That is the involvement of one state in the breach by another state of its obligations. And it's had a somewhat checkered history. It's formulated in quite general terms in Article 16, and it had surprising levels of support in the General Assembly in the discussion on the ILC articles. Since then, the International Court has endorsed Article 16 as reflective of international law, even though the commentary to Article 16 qualifies it in important respects. It's still an area which is the subject of considerable debate. And if, as I hope, does not happen, the ILC articles are referred to a diplomatic conference, you can expect fireworks on Article 16.
I take your microphone. This is like a folk performance when there's only one microphone. I think 4 questions is the perfect number because we also have to wine and dine Judge Crawford after the lecture. So it remains to me to say that I have never had the honour of being your student directly, James, but I have been your close student through much of your work, and I've had the great privilege of being a contributor to the volume, The Cambridge Companion to International Law, that you edited with Marti Koskiniemi, and got to experience firsthand the forensic gaze that I don't envy all of those people appearing before you having to experience, and just other stories of the phenomenal rigour and capacity for work. I remember my colleague Margaret Young, who was Judge Crawford's PhD student, telling me once that she sent James her PhD draft thesis. I hope there's no PhD student of mine in the room, because she sent him the draft and 12 hours later he had sent it back with comments. So nobody should take that as a model, but it is an extraordinary testament to the not only mental acuity but also just extreme generosity with which you approach things. I think it's truly astonishing that you have such a busy number of lives. I can't even begin to live up to the example that you set. So please join with me in thanking James very much for that wonderful and thought-provoking lecture.